in the courts. Silence in the court.
Touching upon issue number 2, does the Supreme Court has the jurisdiction to impose a time-bound framework? And we believe yes. The Supreme Court has established in Ramaiah versus Deputy Speaker in 2016. The court struck down the governor's unilateral decision. It's very important. The court struck down the governor's unilateral decision. This has to be underlined, Your Lordship, to advance the assembly session. So, any given time. What is your name? My name is Sherry.
Since my co-counsel has already dealt with issue number 1 and 2, I'll be dealing with issue 3 and later proceed with issue 4. So here issue 3 being whether the absence of any reason. So the petitioner here would humbly submit before this honorable court that yes, the absence of reasoning from the governor for withholding the assent on the bill does infringe on the constitutional right. It is clearly stated in the MOOT proposition that the founding fathers of the constitution manifest the unity and diversity principle as well as the principle of cooperative federalism. As such, the relationship between the center and states, cooperative federalism here. I would like to bring to the notice of this honorable court the case of SR Ramaiah. Uphold the spirit by ensuring that there is legitimate legislative functions of the state which are not put at halt by indefinitely withholding the assent to give to both the bills, that is the bill of here the actions of the governor undermine the legislative authority of the federal balance between the union and that of the state governments as well.
Whether this Article 200 or any article in the Constitution states anything about time limit?
No such time limit that is being given under any article of the Constitution of Serbia, where it says that in so and so time limit the government has to give assent to the bill and then pass it. So here, moving on, I would like to state that.
No, I would like to look into article as early as possible. Somewhere it is stated. So
That is, yes, Your Honor.
read out which article is that?
In Article 200.
It is specific, correct? It says assent of the bills.
By the Legislative Assembly of a state, or in the case of a state having a legislative council, has been passed by both houses of the legislature of the state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill or that he withholds assents.
Like vigilantly and it does not mandate the state, and constitutional morality should follow the principle of constitutional morality. It does not give him the permission to indefinitely and it is also which is causing a chaos and public welfare. If we are concerned with public welfare, I would like to draw your lordship's attention.
The bills are very much, very.
Please repeat.
You are telling that the bills are, it has to be passed for the welfare.
Affecting the rural healthcare delivery, and also it is causing unrest among the people. The people are not getting. Should be assented or any such declaration must.
That's the prescribed date as prescribed under the Constitution.
Indeed not. Your Commission report suggests that 6 months maximum should.
Are you not putting indirect pressure on the governor?
We are not putting indirect pressure on the governor, and the governor has.
Rather, you are putting direct. One more allegation against him that he is not performing.
In the Constitution itself, it is written that he shall declare. So where is the declaration, Your Lordship? This is in question. He has not declared anything at all.
What?
The delay. But then again, it was completely ignored by the governor, Your Lordship.
He is not concentrating.
You are very clear in your memorials, but unfortunately you are not able to explain what is replicated in the memorials.
Somebody has drafted it. We have not drafted it. But now also we have so many materials in the memorials. So that indicate that answer.
D.D. Basu, in the commentary on the Constitution of India, discussed the constitutional limitations upon the legislative power, where he states that, as the opening words of Article 245 Clause 1 say, the legislative power of both have introduced 11 bills, which has included Public Healthcare Expansion Bill 2024, means of judicial review, And in the case of state of Punjab, this is Principal Secretary to the Governor, which has been consistent, followed since the constitution was adopted, or to the Governor. The principle cements the bedrock of the constitutional foundation that the power to take decisions affecting the governance of the state with the elected arm of the government. The governor is intended to be a constitutional statement guiding the government on the matters of constitutional concern. Governor submitted that the governor was a part of the state legislature under Article 168. Therefore, ministers and should act accordingly without infringing the constitutional rights of the Malayalam State Legislative Assembly. In the case of Ramaiah Kapoor vs. State of Punjab, the Supreme Court held that the same position of India, etc. vs. Valluri Basavaya Chowdhury, etc. The court decides that it is that true, the legislator of the state includes the governor and that the bill passed by the state legislature assents of the governor. The right of the governor to send message to the houses of the
Stop
legislature.
here. You are going against your own argument.
Lordship
Cannot grant the assent of the only if it is the intention and object and purpose of followed or protecting the concept of public welfare, then it has to be granted.
where Article 163 is attracted when there is a factually two parties. Those classes of cases where order have been passed by the minister or the council of ministers in accordance with the rules of the executive business without any actual reference to the government. Of a state executive power, the governor will not be constitutionally contempt the exercise of state administrative duties without the aid and advice of the council of ministers. The nature and scope of the duties of the chief minister and the corresponding rights and powers of the governor are to be understood in the context of their representative roles. Responsibility enables governor to discharge effectively this multifaceted role. Hence, the governor should act harmoniously and in the constitution does not specify how far the discretionary power of the governor extends, and thus state legislature. If you are satisfied with the issue,
Briefly.
the prolonged governor's inaction on the bills infringes the fundamental rights of the people of the state of Malayalam. The bills passed by contravenes the principle of equality. Enactment of legislation has an adverse effect on people's lives, health or well-being as those contravenes on the public welfare and health. Lordships. The means as defined by Article 12, thus it includes not only the legislative as well as the executive organ of the state but also local authorities, instrumentalities and the agencies of the government. The term rule of law means that no man is above the law and that every person, whatever has been ranked or conditioned, is subjected to the ordinary law of the land and is amendable to the jurisdiction of the ordinary tribunals.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ನಾನು ಅರ್ಪಿತಾ ಆದಿತ್ಯ, ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಪಟೇಲ್ ಲಾ ಕಾಲೇಜ್. ಇವತ್ತು ನಮ್ಮ ಪ್ರಥಮ ಮೂಟ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನನ್ನು ಇನಾಗ್ರೇಟ್ ಮಾಡಿದ್ದೀವಿ. ಅದಕ್ಕೆ ನಮ್ಮ ಹತ್ರ ಅರವಿಂದ್ ಲಿಂಬಾವಳಿ ಸರು ಮತ್ತು ಜಸ್ಟಿಸ್ ಸಂತೋಷ್ ಹೆಗ್ಡೆ ಸರ್ ಇಬ್ಬರೂ ಬಂದಿದ್ದರು ಇನಾಗ್ರೇಷನ್ಗೆ. ಅವರಿಗೆ ನಮ್ಮ ಕಡೆಯಿಂದ ಹೃತ್ಪೂರ್ವಕವಾದ ಧನ್ಯವಾದಗಳು. ಅವರ ಬ್ಯುಸಿ ಸ್ಕೆಡ್ಯೂಲಲ್ಲಿ ಬಂದು ಇನಾಗ್ರೇಷನನ್ನು ನಡೆಸ್ಕೊಟ್ಟು ಹೋಗಿದ್ದಾರೆ. ಹಾಗೆ ನಮ್ಮ ತಾತನ ಹೆಸರಲ್ಲಿ ಪಟೇಲ್ ಎ ರಾಮಯ್ಯ ಫಸ್ಟ್ ಮೂಟ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನನ್ನು ಶುರು ಮಾಡಿದ್ದೀವಿ. ನನಗೆ ಚೆನ್ನಾಗಿ ಗೊತ್ತು, ನಮ್ಮ ತಾತ ಮೇಲ್ ಎಲ್ಲೋ ಅವರ ಆಶೀರ್ವಾದವನ್ನು ನಮಗೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಖಂಡಿತವಾಗಿಯೂ ಅವ್ರ ಕನಸಿತ್ತು ಇದು, ನಾವು ಈ ಲಾ ಕಾಲೇಜನ್ನು ತುಂಬ ಎತ್ತರವಾಗಿ ಬೆಳೆಸಬೇಕು ಅಂತ. ಆ ಕನಸನ್ನು ಇವತ್ತು ನಾವು ನನಸು ಮಾಡಿದ್ದೀವಿ ಅನಿಸ್ತಾ ಇದೆ. ಅದಕ್ಕೆ ಅವ್ರ ಹೆಸರಲ್ಲೇ ಪಟೇಲ್ ಎ ರಾಮಯ್ಯ ಮೆಮೋರಿಯಲಲ್ಲಿ ಫಸ್ಟ್ ಮೂಟ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನನ್ನು ಶುರು ಮಾಡಿದ್ವಿ. ಈ ಕಾಂಪಿಟೇಷನ್ಗೆ ಹಲವಾರು ಸಿಟಿಗಳು ಫುಲ್ ಇಂಡಿಯಾಯಿಂದ, ಕೇರಳ, ಕೊಯಂಬತ್ತೂರು, ಪುಣೆ ಎಲ್ಲ ಕಡೆಯಿಂದ ಬಂದಿದ್ದಾರೆ ಮಕ್ಕಳು. ಅವ್ರಿಗೆಲ್ಲರಿಗೂ ನನ್ನ ಕಡೆಯಿಂದ ಆಲ್ ದ ಬೆಸ್ಟ್ ಅನ್ನು ತಿಳಿಸೋಕ್ಕೆ ಹೇಳಕ್ಕೆ ಇಷ್ಟಪಡ್ತೀನಿ. ಮತ್ತು ಅವ್ರಿಗೆಲ್ಲರಿಗೂ ಕಂಗ್ರ್ಯಾಚುಲೇಷನ್ಸ್, ಮೇ ದ ಬೆಸ್ಟ್ ಟೀಮ್ ವಿನ್ ಅಂತ ಹೇಳಿ ಅವ್ರಿಗೆಲ್ಲ ಕಂಗ್ರ್ಯಾಚುಲೇಷನ್ಸ್ ಹೇಳಿ ಮತ್ತೊಮ್ಮೆ ಅವರೆಲ್ಲ ಮಕ್ಕಳಿಗೂ ಇಲ್ಲಿ ಬಂದು ವೇರಿಯಸ್ ಸಿಟೀಸಿಂದ ಇಲ್ಲಿ ಮೂಟ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡ್ತಾರವ್ರಿಗೆ ಎಲ್ಲರಿಗೂ ಆಲ್ ದ ಬೆಸ್ಟ್ ಹೇಳಲು ಇಷ್ಟಪಡ್ತೀನಿ.
warmly welcome our respected judges to this 525. Each team shall get the time of 45 minutes to present their cases. Each qualified team shall communicate the court clerks about the allocation of time for 45 minutes. No team shall reserve more than 5 will be allowed to communicate the team with the discreet manner. Please maintain the court decorum. Teams, kindly introduce yourself by the given team code only. If our respected judges permit, we will start with our oral rounds.
1995, when he was appointed as a civil judge serving at various key locations such as and was later appointed as the Registrar General of High Court of Karnataka, a position he held until August 2022. He was appointed as Additional Judge of High Court of Karnataka and took oath on 16th of August 2022. He was elevated to Permanent Judge on 16th of April.
With the first two issues, and I will be taking 20 minutes of the court's precious time to address the same. And my co-counsel will be dealing with the last. The petitioners have approached this honorable bench under Republic of Serbia after its independence in the year 1947 was envisioned as sovereign, socialist, secular, democratic economy of states and their elected legislators. Your Lordships, in the year 2021, the Malayan People's Party have secured a clear mandate. However, of these, only 2 routine administrative bills received assent from the Honorable Governor. The remaining 9 bills have neither been assented, nor returned, nor reserved for presidential consideration, and no reason have been given. Exercising their legislative competence, have passed 11 bills which are of welfare oriented after thorough debates and deliberations without even assigning the reason for such inaction. And if the silence continues, Your Lordship, unchecked, if Your Lord's permit, may I start with the statement of the issues. Issue 1. Whether the Governor's prolonged delay in deciding bills submitted under Article 200 violates the constitutional principles of federalism and democratic governance under Serbian constitution, infringes on the constitutional rights of the Malayan State Legislature. And last issue, Your Lordships, whether the Governor's prolonged inaction on the bills violates the fundamental rights of the people on the state of Malayan. If Your Lordships permit, may I start with my first issue. In the year 2000, Mrs. S. Rajora was appointed as Governor of Malayan by the President of Serbia, Mr. Dristidi, under Article 155 of the Serbian. She has also been described as a useful player in the channel of protect and defend the constitution and the law. Only 2 bills and kept 9 other bills pending for several months, which have neither been approved nor explicitly returned to the Assembly. Yes, Your Lordships.
No reply by the Governor.
Pardon, Your Lordships, I am not able to hear.
No reply by the Governor. What was the response of the legislature?
So that is the reason we received it.
Was there any communication between the Governor and the legislature?
Didn't give any official statement from the Governor's office.
No. When does it come? Like, what option they have got under Article 200?
I am going to explain that.
Either giving assent or.
Yes, Your Lordship, I am going to submit in my further arguments, Your Lordships.
Now there is only a delay in giving them.
Yes, Your Lordships.
Amounts to violation of fundamental rights.
Your Lordship, that will be dealt in the 4th issue and dealt by my co-counsel, Your Lordships.
Issue number 1 is that
it violates Article 200, Your Lordships.
you said the violation of
The provision Article 200 the word shall declare her actions such as assent, withhold, return for consideration, and any actions whatsoever. In the very next line, in the case of Punjab versus Principal Secretary to the Governor, it is stated that failure to take call and keeping a bill duly passed for indeterminate period is a course of action. Your Lordship, going by the indefinitely and the prolonged delay, if the manner of doing something, if the manner of doing a particular act is prescribed under any provisions, that act must be done in that manner or not at all. In the very case of Taylor versus Taylor, further delay in acting on the bills violates Article 200 and contravenes to the constitutional provisions. Constitutionally bound to act under Article 200. Prolonged inaction without justification is ultra vires to Article 200 of the Serbian Constitution. Your Lordship, it's humbly submitted that the act of the Governor has amplified and hampered the constitutional principles of federalism as well as democratic governance.
The word that passed bill to his will, say, for an indefinite period. Now the question is, what is indefinite period? whether we have a state number. Now the question is, what are the things which he cannot ask on for facts, he can ask on law. Suppose a bill violates Parent Act. See, this is going against this Parent Act, that is forbidden there and you are allowing it. Now the question of the file, switch on and you are immediately sitting the bill. Is it that way?
But the court should
take time. See, now the question is, he is a constitutional functionary.
Under Article 200, your lordship, there is no...
Do you mean to say how long? Do you mean to say till eternity he is not going to hold?
No, your lordship, according to the Sarkaria, it depends, your lordship, it's indefinite.
See, one must be practiced. Now, not the question of setting how long, what is reasonable time. Go ahead.
Yes, your lordship. It is pertinent to note that the forefathers of the Constitution also manifest cooperative federalism, as both union and state cooperatively communicate with each other. Your lordships, please refer paragraph number 16. Dr. B.R. Ambedkar saw...
1 minute.
Yes, your lordship.
Dr. B.R. Ambedkar, perhaps,
Your lordship.
say it is 1 minute. We are not concerned here by the nature of our economy, the form of government, whether it is unitary or federal. See, now the question is, it is a federal constitution with unitary feature.
Exactly.
Chow chow.
Yes, yes.
Is it not? No, we are not concerned with the nature of constitution.
It has been mentioned in the facts.
Let it be.
Yes, your lordship.
What is there? You should have whether governor can withhold it.
Yes, by the state to influence by the center to do so, which is explained in the later parts of my submission, your lordships.
Due to starvation.
Not to the starvation, but they were expecting the rights.
What kind of fundamental rights are being affected?
No, your lordships, they were expecting the rights from their own will of the people. Their normative substantive bills were withheld, your lordship. That is the reason. Yes, your lordship.
He has made it clear.
Yes, sir.
His lordship has said.
Yes.
The issue is only one thing.
Yes, your lordship.
According to you, there is because of the prolonged delay, the state has been affected.
Yes, your lordship.
That is so. How the rights of the governor have been misused.
How the rights of the governor.
The very prolonged delay amounts to a misuse of powers or non-use of the.
When a person immediately say that 6 months for every bill.
But leaving
And
that.
1 minute. So if the bill is of 100 pages, 7 months. If the bill is of 1000 pages, 2 years. Right? See,
No,
the
Your Lordship.
question is
The Article 200 doesn't mandate any timeline. That doesn't mean that.
object.
Yes, sir.
Is it not so? Whether the rules are followed such as golden rule, literal rule, and mischief rule. So, suppose they see now the question is that they have to grant right after the thing. No? Okay, then it was discussed. You call the law as Muslim Women's Protection Act and you are taking away the right. What is this? Is it not? So what we are asking is whether whether the governor can sleep over the matter.
Yes, sir.
Is it not so? Or is he expected to read?
Myself Gunjan Chandawat and I am teaching law at Patel Law College, and today we have organized the first Patel A. Ramaiah Memorial Moot Court competition, in which we have seen participation from all over Karnataka as well as the neighboring states such as Maharashtra. One team has come from Pune, one team has come from Hyderabad. So overall we have around 27 to 28 teams coming over and arguing, and this is a 3-day program wherein the first day is all about the preliminary round, the second is the quarter final and the semi-finals, and the last day is the finals.
The light of knowledge and learning is symbolized through the traditional lighting of the lamp.
ಎಲ್ಲ ಕೂಡಿಸ್ಕೊಂಡು ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಕಾಲೇಜಿನ ಪರವಾಗಿ ನಾವು ಅಭಿನಂದನೆ ಸಲ್ಲಿಸ್ತೇವೆ. ಹಾಗೆ ಅವರು ನಮ್ಮ ಕ್ಷೇತ್ರದ ಈಗ ಅವರು ಶ್ರೀಮತಿಯವರು ಶಾಸಕರಾಗಿದ್ದಾರೆ. ಆದರೆ ನಮ್ಮ ಅಪೇಕ್ಷೆ ಏನಂದರೆ ಅವರೀಗ ಕೇಂದ್ರಕ್ಕೆ ಇದೇ ಥರ ಕೇಂದ್ರಕ್ಕೆ ಹೋಗಿ ಅಲ್ಲಿ ಮಂತ್ರಿಗಳಾಗಿ ನಮ್ಮ ದೇಶದ ಸೇವೆ ಮಾಡಬೇಕು ಅನ್ನೋ ನಮ್ಮೆಲ್ಲರ ಅಪೇಕ್ಷೆ ಇದೆ. ಕಾಲೇಜಿನ ಪರವಾಗಿ ಎಲ್ಲರೂ ನಡೆಸ್ತೀವಿ. ನಂತರ ನಮ್ಮ ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರಾದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ್ಯಾಯಾಧೀಶರಾದ ಸಂತೋಷ್ ಹೆಗ್ಡೆ ಅವರು ಅವ್ರ ಬಗ್ಗೆ ನಿಮ್ಗೆ ಆಲ್ರೆಡಿ ಎಲ್ಲ ಗೊತ್ತಿರುತ್ತೆ. ಎಲ್ಲ ಯೂಟ್ಯೂಬಲ್ಲಿ ಅವ್ರು ಮಾತಾಡೋ ಒಂದೊಂದು ವರ್ಡ್ಗೂ ನಮಗೆ ರಕ್ತ ಚಿಮ್ಮುತ್ತೆ. ಆ ಥರ ಮಾತಾಡ್ತಾ ಇದ್ರೆ ನಮ್ಮ ದೇಶದಲ್ಲಿ ಏನು ನಡೀತಾ ಇದೆ ಇವಾಗ ಲಂಚ ಭ್ರಷ್ಟಾಚಾರದ ಬಗ್ಗೆ ಅವರು ಹೇಳ್ತಾನೆ ಇರ್ತಾರೆ. ನೀವು ನೋಡಿರಬೇಕು, ಯಾವುದೇ ಭಾಷಣ ಮೇಲೆ ಫಸ್ಟ್ ಅವ್ರು ಹೇಳೋದಿದೆ. ಈ ಭ್ರಷ್ಟಾಚಾರಕ್ಕೆ ಕಾರಣ ಏನಂದರೆ ಸಾರ್ ಹೇಳ್ತಾ ಇದ್ರು, ನಾವು ಚಿಕ್ಕ ವಯಸ್ಸಲ್ಲಿದ್ದಾಗ ಅವ್ರು ಬಂದಿರೋರು ಈಗ ಬಂದಿದ್ದು ಭ್ರಷ್ಟಾಚಾರ ನಡೀತಾರೆ. ಈಗ ನಾವು ತಡೆಗಟ್ಟಬೇಕಾದ್ರೆ ನಮ್ಮ ಈಗಿನ ಹುಡುಗರು ಇವಾಗ ಅದನ್ನು ಪಾಲಿಸಬೇಕು. ಭ್ರಷ್ಟಾಚಾರ ನಡೀಬೇಕಾದ್ರೆ ಅದನ್ನು ಹುಡುಗರಿಗೆ ಅವರು ಭ್ರಷ್ಟಾಚಾರ ನಡೀಬೇಕಾದ್ರೆ ಅವ್ರು ಹೇಳೋ ಮಾತುಗಳನ್ನು ಕೇಳಿ ಅದಂತೆ ನಾವು ಫಾಲೋ ಮಾಡೋದು ನಮ್ಮ ಕರ್ತವ್ಯ. ಅವರೊಂದು ಎಕ್ಸಾಂಪಲ್ ಅವ್ರು ಆಲ್ರೆಡಿ ಎಕ್ಸಾಂಪಲ್ ಹೇಳ್ತಾರೆ. ಲೋಕಾಯುಕ್ತರಲ್ಲಿ ನೀವು ಶ್ರೀಮಂತರಾಗಿ ಬೇಡ ಅಂದಿಲ್ಲ, ಒಳ್ಳೆ ಕಷ್ಟಪಟ್ಟು ಸಂಪಾದನೆ ಮಾಡಿ ಕೋಟಿ ಸಂಪಾದನೆ ಮಾಡಿ, ಆದರೆ ನ್ಯಾಯಯುತವಾಗಿ ಸಂಪಾದನೆ ಮಾಡಿ, ಒಬ್ಬರು ಜೋಬಿಗೆ ಕೈ ಹಾಕಬೇಡಿ, ಲಂಚ ತಗೊಳ್ಬೇಡಿ, ಮಾಡಿ ಟ್ಯಾಕ್ಸ್ ಕಟ್ಟಿ ನ್ಯಾಯಯುತವಾಗಿ ಸಂಪಾದನೆ ಮಾಡಿ. ಅದು ಯಾರು ಬೇಡ ಅನ್ನೋಲ್ಲ. ಅದರಲ್ಲಿ ಆ ಥರ ಅವ್ರಿಗೆ ಏನೇ ಅದು ಸಂಪಾದನೆ ಮಾಡಿ ಸಂಪಾದನೆ ಬೇಡ ಅನ್ನೋದು ಯಾರಾಗಿಲ್ಲ ನನಗೆ. ಅದೇ ಥರ ಅವರು ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಹೇಳ್ತಾರೆ. ಒಬ್ಬರು ಆಮೇಲೆ ನಿಮಗೆ ದುರಾಸೆ ಅನ್ನೋದು ನಮಗೆ ಬರಬಾರ್ದು. ಆಸೆ ಇರಲಿ, ನಾವು ಬದುಕಬೇಕು ಅನ್ನೋದು ಆಸೆ ಇರಬೇಕು, ದುರಾಸೆ ಇರಬಾರ್ದು. ಇನ್ನೊಬ್ಬರು ಜೋಬಿಗೆ ಕೈ ಹಾಕಬಾರ್ದು. ಅದು ಮೇಲು. ಆಮೇಲೆ ಬಂದು ಇನ್ನೊಂದು ಎಕ್ಸಾಂಪಲ್ ಹೇಳ್ತಾರೆ. ಮೊದಲೆಲ್ಲ ಸಾರ್ ಹೇಳ್ತಾರೆ, ಇವರು ಹೇಳಿದ್ದಾರೆ, ಮೊದಲು ಹೇಳ್ತಾರೆ ರೌಡಿಗಳು ಅಂದರೆ ಫಸ್ಟ್ ರೌಡಿಗಳು ಕಳ್ಳರು ಅಂದರೆ ಜೈಲಿಗೆ ಹೋದ್ಮೇಲೆ ಊರಿಂದ ಆಚೆ ಇಡ್ತಾ ಇದ್ರಂತೆ. ಅವ್ರು ಯಾರು ಕೆಲಸ ಕೊಡ್ತಾ ಇಲ್ಲ. ನಾನು ಎಕ್ಸಾಂಪಲ್ ನೋಡಿದ್ದೀನಿ. ರೌಡಿಗೆ ಕೆಲಸ ಕೊಡದಿದ್ರೆ ನ್ಯಾಯಾಧೀಶ ಮನೆಯಲ್ಲೇ ಕೆಲಸ ಮಾಡ್ಕೊಂಡ ಇದ್ರು, ಅವ್ರು ಊರಿಗೆ ಸೇರಿಸ್ತಾ ಇರಲಿಲ್ಲ. ಆದರೆ ಈಗಿನ ಕಾಲದಲ್ಲಿ ರೌಡಿಗಳಿಂದ ಅಲ್ಲಿ ಜೈಲಿಂದ ಈಚೆ ಬರುವಷ್ಟೊಂದು ಹೂನಾರ ಹಾಕೊಂಡು ಕರ್ಕೊಂಡ್ಬರ್ತಾ ಇದ್ದಾರೆ. ಆ ಥರ ಅವ್ರಿಗೆ ಸನ್ಮಾನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಕಾಲ ಈ ಥರ ಯಾಗಿದೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಅವರು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ದಾರೆ, ನೋಡಿರ್ತಾರೆ ಅವರು. ಆ ಥರ ಅವರೆಲ್ಲ ಮಟ್ಟ ಹಾಕಿದ್ದು ಅವ್ರ ಕಾಲದಲ್ಲಿ ಎಷ್ಟೆಷ್ಟು ಭ್ರಷ್ಟಾಚಾರಕ್ಕೆ ಸ್ವಪ್ನವಾಗಿದ್ರು ಅವ್ರು ಸಾಗೋರು ಅವ್ರ ಕಾಲದಲ್ಲಿ. ಆಮೇಲೆ ಇನ್ನೊಂದು ಎಕ್ಸಾಂಪಲ್ ಹೇಳಿರ್ತಾರೆ, ಅದು ನೀವು ನೋಡಿರ್ತೀರ, ಕೇಳಿರ್ತೀರ. ಒಂದು ಸಿಂಪಲ್ ಎಕ್ಸಾಂಪಲ್ ಹೇಳ್ತೀನಿ. ಒಂದು ಯಾರೋ 75-80 ವರ್ಷ ವೃದ್ಧೆ ಅವ್ರಿಗೆ ಮಗ ಒಂದು ಮನಿ ಆರ್ಡರ್ ಕಳಿಸ್ತಾರಂತೆ. ಮನಿ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ, 250 ರೂಪಾಯಿ ತಾಯಿ ಜೀವನಾಂಶಕ್ಕೆ ಬಿಟ್ಟು. ಆ ಪೋಸ್ಟ್ ಮ್ಯಾನ್ 250 ರೂಪಾಯಿ ಕೊಡೋದಕ್ಕೆ 10% ಕಮಿಷನ್ ಕೇಳ್ತಾರಂತೆ ಅವ್ರ ಹತ್ರ. 10% ಅಂದರೆ 25 ರೂಪಾಯಿ. 25 ರೂಪಾಯಿ ಕೊಡದೇ ಇರುತ್ತೆ ಅಮ್ಮ 3 ಸಾವಿರ ವಾಪಸ್ ಕಳಿಸ್ತಾರೆ ಅಂತೆ ಆ ಪೋಸ್ಟ್ ಮ್ಯಾನ್. ಏನೋ ದುಡ್ಡು ಲಂಚ ಕೊಡದಿರೋದಕ್ಕೆ. ಅಂಥ ಕೇಸ್ ಸಾಲ ಹತ್ರ ಬಂದಿದೆ ಅವ್ರ ಹತ್ರ ಕೇಸ್ ಹ್ಯಾಂಡಲ್ ಮಾಡೋದಕ್ಕೆ. ಆ ಕೇಸನ್ನು ಒಳ್ಳೆ ಪೊಲೀಸ್ ಅಧಿಕಾರಿ ರೆಫರ್ ಮಾಡಿದಾಗ, ಏನು ಸರ್ ಇದು 25 ರೂಪಾಯಿ ಕೇಸ್ ನಮ್ಮ ಹತ್ರ ತರ್ತೀರಾ ಅಂದ್ಬಿಟ್ಟು ಅಷ್ಟು ಅವ್ರ ಹತ್ರ ಕೇಳಿದಂತೆ. ನಿಮ್ಮ ಹತ್ರ ಯಾವೆಲ್ಲ ಪೊಲೀಸ್ ಇರುತ್ತೆ ಅವ್ರಿಗೆ ರೆಫರ್ ಮಾಡಿ, 25 ರೂಪಾಯಿ ಕೇಸ್ ನಮ್ಗೆ ಯಾಕೆ ಅಂದರೆ ಎಲ್ಲಿ ಮಾನವೀಯತೆ ಇದೆ. 25 ರೂಪಾಯಿ ಕೇಸ್ ಅಂದರೆ ಆ ವೃದ್ಧೆಗೆ ಅದೇ ಅವ್ರ ಜೀವನ, ಅದು ದುಡ್ಡು ಬಂದರೆ ಜೀವನ, ಇಲ್ಲ ನಾವು ಜೀವನ ಮಾಡೋದಕ್ಕೆಲ್ಲ ಆಗುತ್ತೆ. ಅಂಥ ಕೇಸ್ ಸಾವಿರಾರು ಕೇಸುಗಳು ಸರ್ ನೋಡಿದ್ದಾರೆ. ನೋಡಿ ಅವ್ರು ಎಕ್ಸಾಂಪಲ್ ಕೊಡ್ತಾರೆ ಯಾವ ಥರ ನಮ್ಮ ರಾಷ್ಟ್ರೀಯತೆ ಮಾನವೀಯತೆ ಇದೆ ಅನ್ನೋದಕ್ಕೆ ಅವರೊಂದು ಎಕ್ಸಾಂಪಲ್. ನಮ್ಮ ಯುವಕರು ಅವ್ರು ಹೇಳೋದನ್ನು ಪಾಲಿಸ್ಕೊಂಡು ಬಂದು ನಮ್ಮ ಭ್ರಷ್ಟಾಚಾರ ಕಡಿಮೆ ಮಾಡಬೇಕು ಅಂತ ತಮ್ಮಲ್ಲಿ ಮನವಿ ಮಾಡಿದ್ದೀವಿ. ಇನ್ನು ಈ ಸಂಸ್ಥೆ ಬಗ್ಗೆ ಹೇಳಬೇಕಂದ್ರೆ, ನಾನು ಸ್ವಲ್ಪ ಅಡ್ವೊಕೇಟ್ ಆಗಿದ್ದೆ. ಸ್ವಲ್ಪ ಒಂದು 5-6 ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದೆ. ನಾನು ಕೇಸುಗಳು ಹೋದಾಗ ಸ್ಥಳಕ್ಕೆ ಬಂತು. ನಾನು ಕೇಸುಗಳು ಬಂದಾಗ ಹೆಚ್ಚು ಕಮ್ಮಿ ಅಲ್ಲೇ ರಾಜಿ ಮಾಡಿಬಿಡ್ತಾ ಇದ್ದೆ. ಆಫೀಸ್ಗೆ ಬಂದಾಗ ಗಂಡ ಹೆಂಡತಿ ಡೈವರ್ಸ್ ಕೇಸುಗಳು ಅದು ಬಂದರೆ ಅಲ್ಲೇ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿಬಿಡ್ತೆ. ಮೇಲೆ ಕೋರ್ಟಿಗೆ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ. ಅದು ನಾನು ಅಷ್ಟು ವರ್ಷಗಳ ಆ ಥರ ಮಾಡ್ತೇನೆ. ನಮ್ಮ ಜೀವನಕ್ಕೆ ಕೇಸ್ ನಡೆಸೋಕ್ಕೆ ನನಗೆ ವಕೀಲನಾಗಕ್ಕೆ ನನಗೆ ಸಾಧ್ಯ ಆಗಲಿಲ್ಲ. ನಾನು ಬಂದು ಅದೇ ರೀತಿ ಸಾಮಾಜಿಕ ಕೆಲಸ ಮಾಡೋಣ ಅಂದ್ಬಿಟ್ಟು ಫಸ್ಟ್ ಪಟೇಲ್ ಪಬ್ಲಿಕ್ ಸ್ಕೂಲ್ ಅಂದ್ಬಿಟ್ಟು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದೆ 2006ರಲ್ಲಿ. ಜಸ್ಟ್ 75 ಹುಡುಗರು ಮಾತ್ರ ಇದ್ದಿದ್ದು. ಅಲ್ಲಿಂದ ಪಟೇಲ್ ಪಬ್ಲಿಕ್ ಸ್ಕೂಲ್ ICSC ಮಾಡಿದೆ. ಮತ್ತು PUC, ಒಂದು ಡಿಗ್ರಿ, BBA, MPC, MBA, ಲಾ ಎಲ್ಲ ಕೋರ್ಸ್ಗಳನ್ನು ಮಾಡಿ ಈಗ 2500 ಮಕ್ಕಳು ನಮ್ಮ ಕಾಲೇಜಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ಇದು 200 ಜನ ಇವರು ಟೀಚರ್ಸು, ಇವರೆಲ್ಲ ಒಂದು 200 ಜನ ನಮ್ಮ ಸ್ಟಾಫ್ ಎಲ್ಲ ನಮ್ಮ ಕಾಲೇಜಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅವರು ಇದೆಲ್ಲ ನಾವು ಮಾಡಬೇಕಾದ್ರೆ ಇದೆಲ್ಲ ನಾವು ಮುಂದುವರಿಬೇಕಾದ್ರೆ ನಮ್ಮ ಟೀಚರ್ಸು, ನಮ್ಮ ಹುಡುಗರು ಸಪೋರ್ಟ್ ಇದನ್ನು ಇಷ್ಟೆಲ್ಲ ಬೆಳಿಬೇಕಾದ್ರೆ ಕಾರಣ ಅವ್ರಿಗೆ ನಮ್ಮ ಕಾಲೇಜಿನ ಬಗ್ಗೆ ಅಭಿನಂದನೆ ಸಲ್ಲಿಸ್ತೇವೆ. 2006 ಮೇಲೆ 2005-2006ರಲ್ಲಿ ಆಮೇಲೆ MBA ಲಾ 5 years ಲಾ ಮಾಡಿದೆ. ಫಸ್ಟ್ 3 years ಲಾ ಮಾಡಿದ್ದೀನಿ, ಆಮೇಲೆ 5 years BCom LLB ಮಾಡಿದ್ದೀನಿ. ಈಗ ನಮ್ಮ ತಂದೆ ಹೆಸರಲ್ಲಿ ಇದನ್ನು ಹಾಗೆ ದೊಡ್ಡ ಮಟ್ಟಕ್ಕೆ ತಗೊಂಡ್ಬಿಟ್ಟು ನಮ್ಮ ತಂದೆ ಹೆಸರಲ್ಲಿ ಮೂಟ್ ಕೋರ್ಟ್ ಇಂಟರ್ ಕಾಲೇಜಿಗೆ ಮೂಟ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನ್ ಇಟ್ಟು ಯಾರು ಇದರಲ್ಲಿ ಉತ್ತೀರ್ಣರಾಗ್ತಾರೋ ಯಾರು ಅವರಿಗೆ ಇಷ್ಟು ಬಹುಮಾನ ಕೊಡ್ತೀವಿ. ಬಹುಮಾನ ಮುಖ್ಯ ಅಲ್ಲ, ಇಲ್ಲೇ ಎಷ್ಟು ಅವ್ರು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿ ಹೋಗ್ತಾರೋ ಅದು ಅವ್ರು ಮುಂದೆ ನ್ಯಾಯಾಧೀಶ ಆಗ್ಬೋದು, ಒಳ್ಳೆ ವಕೀಲರಾಗ್ಬೋದು. ಆಗ ಒಂದು ಇದು ಸ್ಟೆಪ್ ಇದು ಮಾಡಿ ಅವ್ರನ್ನ ಬಂದು ಅವರೆಲ್ಲ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿರೋದಕ್ಕೆ ಅವ್ರು ನಮ್ಮ ಕಾಲೇಜಿನ ಪರವಾಗಿ ಅಭಿನಂದನೆ ಸಲ್ಲಿಸ್ತೇನೆ. ಥ್ಯಾಂಕ್ ಯು.
A very good morning and welcome everyone to our first national level moot court competition. I think my dad already stated that we are doing this moot court competition under my grandfather's name. A bit to tell about him because it was his dream to develop the village. That's how the entire group of institution gets the name as Patel. My grandfather Patel Ramaiah served as the sarpanch and the head of this village. Since then it's a dream of more than 50 plus years where he said me and my family should do something to this village, obviously something to the nation as well. So today we are here, me, my father and my mother, who are trying to develop the institution and serve the needy students of the society. If you see what is Patel known for, first thing we are known to educate the students who are the cadre of the low level average working parents, where we believe in that and we follow our motto that yes, even those students can be educated, even those students can be enlightened in the society, and yes, those cadre of students can also become one day in the country. Apart from that, to tell about our versatility, we even provide free seats to parents, to students who have lost their parents in COVID, to the parents who are already working in the society or in the Navy or as soldiers. And we also are very proud to tell we get letters from our sitting MLA Manjula Madam, who is the wife of our Arvind sir, where she recommends students to our to our college and telling for the minimal fees. That is how Patel versatility is going along in the Bangalore city, where we are known that yes, we can provide education to the students who are also coming from the entire government belt, and we are showcasing ourselves. If you see today, our entire Patel Institute of Science and Management and Patel Law College, where we have 100% results, and we have more than 7 students who have taken 100 on 100 in their subjects across the university. It is not 100 on 100 in our college, it is the university results, entire Bangalore North University, where our students have taken 100 in each subject, and we also have a rank holder where our student holds the second rank in the North University. So what we want to convey is every student has their right to get education. So I think talking about rights today program is one of the most important schedule in the history of Patel College, where we have started our first national level moot court competition under the name of my grandfather. I am sure he is somewhere above blessing all of us and feeling extremely proud that today we have grown up to this level, and as my dad said, we are educating around 2,500 students across the group from KG to PG, and we are serving the nation, and we are making sure yes, those students can also stand one among the society and one among the Indian national citizens. So to you here students and various, I know students have come from various colleges, so wishing you all the very best. You have come here, and as my dad rightly said, you have come here and this is an experience, and tomorrow you can go to any level. So the scheduled program is completely dedicated to the students of Patel Law College and the students across India. So make use of it, and any help, any guidance, we Patel who are known for hospitality are always there for you, always ready to serve you. Along with you, we are also making sure the program should become a grand success. So wishing all the best and congratulations to entire student community from Patel Law College as well as other colleges. We welcome you and wishing you all the very best for your program. Last but not the least, I have to give my heartfelt thanks for the program success. So firstly, I would start with our chief guest, Arvind sir, and our guest of honor, Santosh Hegde sir, who have made their time in their busy schedule come here to wish and congratulate our students. Sir, to both of you standing here, we really give our heartfelt thanks from the entire management side for coming here and making your presence here today. I congratulate and thank our principal and our campus director, sir.
Good morning, everyone. It's my privilege to introduce Honorable Mr. Justice and Santosh Hegde, a distinguished jurist and a former judge of Supreme Court of India. Here is an overview of his remarkable career and achievements. To talk about Sir's education, studied at St. Aloysius School, Bangalore and Madras Christian School, Chennai. Sir has graduated with a law degree from University Law College, Bengaluru, formerly called Government Law College in 1965. To talk about Sir's career highlights, Sir was being appointed as an Advocate General of Karnataka in February 1984 and held the position till August 1988. Sir was appointed as a Solicitor General of India in December 1989 and later Solicitor General of India on April 25, 1998. Sir was appointed directly from the bar as a judge of the Supreme Court of India on Jan 8, 1999 and retired in June 2005. Sir served as Lokayukta Ombudsman for Karnataka State from August 3, 2006 to August 3, 2011. To talk about Sir's awards and honors, Sir have an honorary doctorate from various universities conferred by University of Mangalore 2005, Karnataka State Open University 2009, Tumkur University 2010, Karnataka State Law University 2011, Alliance University 2011 and Hampi Kannada University 2016. Other notable awards: Man of the Year by Times of India 2010 and 11, Vijaya Karnataka 2006 and 2010, NDTV Indian of the Year Award 2010, Bangalore Hall of Fame Award 2010, Paul Harris Award by Rotary, Public Service Excellence Award 2011, Sitaram Jindal Foundation Honor Award 2011. It is with great pleasure that I welcome Honorable Mr. Justice N. Santosh Hegde to Patel Law College for our national level moot court competition. We are honored by his presence. We look forward to his valuable insights and we welcome you, sir. Without ado, I request Honorable Mr. Justice N. Santosh Hegde to address the gathering. I am sure many budding lawyers will be waiting to listen to his inspiration speech. It's over to you, sir.
ಕೂಡ ಕನ್ನಡದಲ್ಲಿ ಮಾತಾಡಬೇಕಂತ ಇದ್ದೆ, ಆದರೆ ಹಲವಾರು ವಿದ್ಯಾರ್ಥಿಗಳು ಕರ್ನಾಟಕದಿಂದ ಹೊರಗಿಂದ ಬಂದವರಿದ್ದಾರೆ. ಅವರಿಗೆ ಕನ್ನಡದ ಅಭ್ಯಾಸ ಇರಲಿಲ್ಲ. 4 ಮಾತುಗಳಲ್ಲಿ ನಾನು ಇಂಗ್ಲೀಷಲ್ಲಿ, ಯಾಕೆಂದರೆ ಪ್ರಿನ್ಸಿಪಲ್ ಅತಿಥಿ ದೇವೋ ಭವ ಅನ್ನುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಾನು ಇಂಗ್ಲೀಷಲ್ಲಿ ಮಾತಾಡಲಿಕ್ಕೆ ಬಯಸ್ತಾ ಇದ್ದೇನೆ. The chief guest of today's function, Home Minister, Government of Karnataka, Shri Arvind Limbavali, Chairman Patel Group of Institutions, Shri R. Sampath Kumar, Vice Chairman Srimati Asha Sampath Kumar, Managing Director Dr. Arpita Aditya, Director Operations Shri Aditya Sharma, Campus Directors Sharat Chandra Kamath, Principal of the College Shri K. Magaswamy, Assistant Professor Gunjan Chandrawat, Student Coordinator Edgar Allen, members of the teaching and non-teaching staff of the institution present here, students, participants from outside the state present here, ladies and gentlemen. First of all, let me congratulate the students of Patel Ramaiah Educational and Cultural Trust for having their last studies in this institution because of the infrastructure which I saw, and I got compared it with this law college I studied in. You are far, far better off, and according to me, you are really blessed to be an institution like this. When I joined law, I did not intend to practice, but I wanted to spend some more time in the hockey field. I was playing for the University of Mysore and State of Mysore, so I wanted hockey to be my professional life. And law was a part-time course. It was not a course which normally anybody preferred, except government servants who were working, who could work from 7 o'clock in the morning till 10 o'clock in the morning, and then go for their work, and which the degree would help them to get a further promotion. The intention of the students at that point of time was not to get into law profession, because it was a difficult profession to earn money at that point of time. And I came out of the law college as a law degree holder and became a lawyer about 5 years later, practicing in somebody's office. You are lucky, because today we come out of the college as a law graduate and a lawyer, capable of practicing in any one of the courts in India, starting from the Supreme Court down to the Court of Magistrate or the Council. Therefore also you are the lucky ones that you come out as a lawyer, not like my time and all. Now because of that, today's program in this college, the MOOT code for all India law students, is a great service, because you learn a lot from outside the law college because of the practical practicing facilities that is necessary in the legal profession. As a matter of fact, you go to court and watch the proceedings before you come to MOOT courts to find out how the proceedings go on in a court, so that you will be ready by the time you come out to the college to argue a matter. Whereas we had to take 4 to 5 years before we could appear before a court. So there's a difference between the law studies that I went through and you people have gone through. My dear students, today law is one of the most important professional courses that people prefer to have. And they have a 5-year course, they have a 3-year course, which will go, both of them will make you a lawyer as you come out of the institution. I want to put it across something which is happening in the legal profession, which is necessary for your future. Please try and understand the law's delays that is causing in the present day situation. Every court is so flooded with the litigation that takes 10 to 15 years for a matter to be decided in one court. And there are what we call speculative litigants who want to go right up to the Supreme Court, and every institution takes 10 years or 15 years. Imagine when will the justice be delivered? It takes, in my assessment, nothing less than 25 to 30 years before a final judgment comes in the present day system. You have to find out a way by which you can change the system, and the principle of the legal profession that justice delayed is justice denied is fulfilled by your generation at least. Otherwise, there is a possibility of underground taking over the legal dispensation. I heard that in commercial cities like Delhi, Calcutta, Mumbai, underground has started taking over the legal profession. They go to one of the parties and say, you want this matter to be settled right outside the court? And if you say yes, then they make a payment, one-time payment that will be made, and they will go to the other side and say, look here, you better agree to whatever the demand the other side is making, otherwise we'll kidnap your daughter, murder your son. Such like profession will start. So in the interest of the legal profession, as also the benefit to the clients that you have, we've got to find out a way by which the legal disputes are settled at the earliest, so that the litigating public can feel satisfied with the profession. One of the reasons which I have examined, and I spoke about it even in the High Court some time back, is the multiple fora you have for settling your disputes. You have a municipal court, you have a civil judges court, you have a district court, you have a High Court, you have a Supreme Court. Imagine if cases take 5 to 10 years in each one of these institutions, when will the justice be delivered? You as lawyers have a very important role to play. Don't ever think that by stopping the number of fora and reducing it to 1 or 2 only, you will lose your professional work. No. Today, legal profession is not confined to civil disputes and criminal disputes only. There are different types of disputes are there. There are different tribunals which are trying as a trial court there. You can work in any one of them. Just take one taxation system. Taxation was not so much in practice when I was practicing the thing, But today, you have direct tax, you have indirect tax, you have customs duties, and so many other factors. And you can become an expert in any one of them and have sufficient income on that. Similar is the service matters, similar is the other disputes that arise, and also multiple disputes are there today, which will keep you busy. So as a lawyer, I don't think if the number of appeals and revisions are restricted, you will be affected anyway in the profession. Anyway, even if you don't try to change the system, you will have to work in only one profession because of one subject. Otherwise, you will be busy, so busy that you will not be able to work in all the fields of law. Therefore, it's my appeal to you to bring about a change in the legal system. For example, in the United States, there are only two courts are there. The trial court and an appeal court. The United States has a Supreme Court, it has a federal court, but none of the normal appeals go there at all. And every litigation has only two fora to dispose of. A trial and one appeal court. And the man who loses in the first court, he loses in the second court. He is fined heavily for misuse of the time of the court and all. If we have that system here in India, I think we can do justice to the litigants who are waiting for decades and decades before they could get it. I've got materials with me in my phone which I will extracted from the thing. Recently, in one case, after 37 years in jail, he was acquitted by the High Court. 37 years a person spends, and a life sentence is only 14 years. Just imagine what sort of a profession you are getting into. You have to change the system, and you can alone do it. They just can't do it. Let there be courts like Municipal Court, Civil Judges Court, High Court, and Supreme Court. But let the work be divided. Here, the courts are flooded with speculative litigation. The litigant knows that he's going to lose the case, but he wants to be there to spend some time because law's delays helps one of the litigant in the litigation. In your interest, in the future of litigation in this country, I suggest that you try to reduce the number of appeal and revision fora. Here today, an arbitration case where 3 Supreme Court judges sit and decide, the award goes for a test before a civil judge. And from the civil judge, it goes to the High Court, then to the Supreme Court. What's the use of an arbitration? You go to arbitration thinking that you will settle the dispute once and for all in one forum. But time spent is giving help to somebody who really doesn't have a merited case. This is a major problem that we have in the legal profession today. Think of yourselves, think of your children who will come into this profession in the future. What type of a system that they will be having? People in litigants will not keep quiet. They will revolt against this system, if not today, sometime later. So please try and change the system by which justice delivered is at the earliest. We have a principle called justice delayed is justice denied. But in view of the prevailing situation, we have another one which says justice hurried is justice buried. So we have a saying for everything. But I personally think that unless the system changes and you are able to finally dispose of the case, maybe maximum 2-3 years, the profession itself is in danger. Second thing is the people who spoke earlier than me did refer to my career as a Lokayukta. Ladies and gentlemen, I have worked in many positions, but when I came to the institution of Lokayukta, I felt till then I was a fraud in the world. I did not know the sufferings of the people. As a Lokayukta, I saw such sufferings of the people. I was wondering why this is happening so. Then I realized people are not responsible for this. The society in which we are is responsible for this. You may say, how does the society, which is an inanimate body, be responsible for what's happening in the society? We people follow what society wants. Today's society respects money and power and nothing else. If you are rich, you are saluted. If you are powerful, you are saluted. An ordinary man has no respect in this society. We talk about an ordinary man, is a useless chap. He doesn't take, he doesn't allow others to take. This is the definition of an ordinary man. My dear students, the greed in the society has reached such level. I don't know what your future is likely to be. In the decade of 50s, scams were running in lakhs. For example, there was a scam called Jeep scam in the decade of 50s. The money involved in that scam was 52 lakhs in importing Jeep vehicles from Great Britain for our soldiers. The following decades, there was a scam called Gophers. In purchasing weapons for our soldiers, the country lost 54 crores of rupees. From 52 lakhs came to 54 crores. Then a scam thereafter, another decade, came to Commonwealth Games. The country lost 70,000 crores. These figures are not mine. These are the figures given by the CAG, the Comptroller and Auditor General of India, to the Government of India. Then came a scam called 2G. The country lost 1,75,000 crores. These are not my figures, as I said. In one scam, whereas in the decade, thousands of scams take place. And in one scam, this much is lost. The next scam thereafter in another decade was Colgate. The country lost 1,86,000 crores. In 1985, then the Prime Minister of India, late Rajiv Gandhi, made a public statement in Mysore, wherein he said, in 1985, out of the government gave 1 rupee for development, only 15 paise reached the target. You go to Google and hear these names and all, Jeep scam, Gophers, Commonwealth Games, 2G, Colgate. Then what Rajiv Gandhi said, everything is there in Google, you go and see that. How can there be any development in this country when so much of money is siphoned out? For this, there is no treatment. Greed has no treatment. There is no medicine for that. People are not afraid of punishment because punishment comes after 50 years. Who is afraid of that? My dear students, for your future and your children's future, the only way out is to change the attitude of the government and society. Build an attitude in yourself or inculcate a value called contentment in life. If you are contentment, you don't get a disease called greed. Now, contentment doesn't mean that when you get a degree, get a job, you don't want to become anything more than that and become a sannyasi. No. You all must have an ambition. Ambition to become somebody big, ambition to become somebody rich. Legitimately earned wealth is no product of sin. It's when you steal from somebody's pocket. If you feed somebody which is not edible, that's when the problem starts. You have contentment in life, you definitely change the attitude of the society. Similarly, there is another value necessary, it's called humanism. We are not born human beings. There is no species called human beings. We are born to a species called Homo sapiens, which has got nothing to do with humanism. Humanism is a value which our elders created in the society. Our poets in Karnataka have written, become what you want to become in life, but become a human being. I have, as of day before yesterday, been to 1,850 educational institutions. This is the 51st one, 1,851, where I tell the students this is a value that should be followed in their heart. There I convey my own message to them. I say, ಹುಟ್ಟುವಾಗ ಮಾನವನಾಗಿ ಹುಟ್ಟದೆ ಇದ್ದರೂ ಜೀವನ ಪಥದಲ್ಲಿ ಮಾನವೀಯತೆಯನ್ನು ಅಳವಡಿಸಿಕೊಂಡು ಸಾಯುವಾಗ ಮಾನವನಾಗಿ ಸತ್ತರೆ ಅದಕ್ಕೆ ಮೇಲ್ಪಟ್ಟಂತಹ ಗೌರವ ಯಾವುದೂ ಇಲ್ಲ. Even though not born a human being, but in the journey of your life, if you acquire humanism and show it to the society, then when you die as a human being. Otherwise, you will not die as a human being. My dear students, there's many things to be told but this is not that. This is the preliminary for moot court competition. I wish all the participants and others all the very best in life, and thank you for giving me this opportunity. Thank you very much.
ಒಬ್ಬ ಪ್ರಾಮಾಣಿಕ ಮತ್ತು ಸಾಮಾನ್ಯರಿಗೂ ನ್ಯಾಯ ಒದಗಿಸ್ತಾ ಇರುವಂಥ ಸುಪ್ರೀಂ ಕೋರ್ಟಿನ ಜಡ್ಜು ಆಗಿ, ಲೋಕಾಯುಕ್ತ ಆಗಿ ಬೇರೆ ಬೇರೆ ಸ್ಥಾನಗಳನ್ನು ನಿರ್ವಹಿಸಿದರೂ ಕೂಡ ಭ್ರಷ್ಟಾಚಾರದ ವಿರುದ್ಧ ಒಂದು ಆಂದೋಲನವನ್ನು ಪ್ರಾರಂಭ ಮಾಡಿರುವಂಥ ಸಂತೋಷ್ ಹೆಗ್ಡೆ ಅವರೇ, ಈ ಕಾಲೇಜಿನ ಚೇರ್ಮನ್ರಾಗಿರುವಂಥ ಸ್ನೇಹಿತರಾದಂಥ ಸಂಪತ್ ಕುಮಾರ್ ಅವರೇ, ವೈಸ್ ಚೇರ್ಮನ್ರಾಗಿರ್ತಕ್ಕಂಥ ಆಶಾ ಸಂಪತ್ ಕುಮಾರ್ ಅವರೇ, ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ಡಾಕ್ಟರ್ ಅರ್ಪಿತಾ ಅವರೇ, ಆದಿತ್ಯ ಶರ್ಮಾ ಅವರೇ, ಪ್ರಿನ್ಸಿಪಾಲ್ ಆದಂಥ ಮೈಲ್ ಸ್ವಾಮಿ ಅವರೇ, ಕ್ಯಾಂಪಸ್ ಡೈರೆಕ್ಟರ್ ಶರತ್ಚಂದ್ರ ಕಾಮತ್ ಅವರೇ, ವೇದಿಕೆಯಲ್ಲಿರುವಂಥ ಎಲ್ಲ ಅತಿಥಿಗಳೇ, ಭಾಗವಹಿಸಿಕೊಂಡಿರುವಂಥ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳೇ, 3 ದಿವಸದ ಹಿಂದೆ ದೇಶದಲ್ಲಿ ಒಂದು ಮಾಕ್ ಎಮರ್ಜೆನ್ಸಿ ನಡೆದಿತ್ತು. ಯಾರಾದರೂ ಭಾಗವಹಿಸಿದ್ರ? ನಮ್ಮಲ್ಲಿ 2 ಕಡೆಗೆ ಆಯಿತು. ನಮ್ಮ ಕ್ಷೇತ್ರದಲ್ಲಿ ITBL ಅಲ್ಲಿ ಮತ್ತು ಸರ್ಜಾಪುರ ರೋಡಿನ ಫೈರ್ ಸ್ಟೇಷನ್ನಲ್ಲಿ ಸೈರನ್ ಮೊಳಗಿದ್ರು. ಕರೆಂಟ್ ಲೈನ್ ಅಷ್ಟೇ, ಯಾಕಂದರೆ ನಾವು ಬಹಳ ದೂರ ಇದ್ದೀವಿ ಅಲ್ಲಿಂದ. ಆ ಮಾಕ್ ಎಮರ್ಜೆನ್ಸಿ ರೆಸ್ಕ್ಯೂ ಆಪರೇಷನ್ಸಿನ ಆಗಿ 2 ದಿನಕ್ಕೆ 3 ದಿನಕ್ಕೆ ಯುದ್ಧ ಪ್ರಾರಂಭ ಆಗಿದೆ. ಇವತ್ತು ಕೂಡ ಸಂಪತ್ ಅವರು ಇಲ್ಲಿ ಮಾಕ್ ಕಾಂಪಿಟೇಷನ್ ಅಂತ ಇಟ್ಟಿದ್ದಾರೆ ಅಲ್ವಾ? ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಬರಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ, ಮತ್ತು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೋದು. ಸಂತೋಷ್ ಹೆಗ್ಡೆ ಅವರು, ಈ ಇಶ್ಯೂ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕೋರ್ಟಲ್ಲಿ ಇಲ್ಲಿರ್ತಕ್ಕಂಥವ್ರು ಹೋಗಿ ಯಾರು ಈ ಸಬ್ಜೆಕ್ಟು ಇಡೀ ಅಂತ ನಾನು ವಿನಂತಿಯನ್ನು ಮಾಡ್ಕೊಳ್ತೀನಿ. ಮಾಕ್ ಕಾಂಪಿಟೇಷನಲ್ಲಿ ಇದು ಒಂದು ಸಬ್ಜೆಕ್ಟ್ ಆಗಿ ತಗೊಂಡ್ರೆ ಯಾರ್ಯಾರು ಯಾವ ರೀತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೋದು ಅಂತ ಆಪರೇಷನ್ ಸಿಂಧೂರ್ ಬಗ್ಗೆ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗೋ ಸಾಧ್ಯತೆಗಳಿದೆ. ಆ ರೀತಿಯ ಒಂದು ಕಾಂಪಿಟೇಷನ್ ಸಂಪತ್ ಕುಮಾರ್ ಅವರ ತಂದೆಯ ನೆನಪಿನಾರ್ಥವಾಗಿ ಇಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಭಾಗವಹಿಸಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಮೊದಲನೇದಾಗಿ ಶುಭಾಶಯಗಳನ್ನು ಕೊಡ್ತಾರೆ. ಯಶಸ್ವಿಯಾಗಿ ಈ ಒಂದು ಸ್ಪರ್ಧೆಯಲ್ಲಿ ಗೆಲ್ಲೋದಕ್ಕೆ ಒಬ್ಬರು ಇಬ್ಬರಿಗೆ ಆಗೋದು ಸಾಧ್ಯ, ಎಲ್ಲರೂ ಗೆಲ್ಲಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಆದರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅನ್ನ ಸರಿಯಾಗಿ ಮಾಡಿ ಅನ್ನುವಂಥ ವಿನಂತಿಯನ್ನು ನಾನು ಮಾಡ್ಕೊಡ್ತೀನಿ. ಸಂಪತ್ ಕುಮಾರ್ ಅವರು ನನಗೆ 2008ರಿಂದ ಪರಿಚಯ. ಇಲ್ಲಿ ಬಂದಾಗಿನಿಂದ ನಾನು ಡಾಕ್ಟರ್ ಅರ್ಪಿತಾ ಅವ್ರ ಹತ್ರ ಹೇಳ್ತಾ ಇದ್ದೇನೆ, ನಿಮ್ಮ ತಂದೆಯವರು ಪ್ರೀ ಯೂನಿವರ್ಸಿಟಿ ಅಂದರೆ PU ಕಾಲೇಜ್ ಇದ್ದೀನಿ. ಆಗಿನ ದಿನಗಳಿಂದ ಈ ಸಂಸ್ಥೆಯ ಒಡನಾಟದಲ್ಲಿ ನಾನಿದೆ. ಮತ್ತು ಕೋವಿಡ್ ಸಮಯದಲ್ಲಿ ಅವಾಗ ಡಿಸ್ಟೆನ್ಸ್ ಮೇಂಟೈನ್ ಮಾಡಬೇಕಾಗ್ತಿತ್ತು. ಇವ್ರ ಮೈದಾನವನ್ನು ನಾವು ಸಂಪೂರ್ಣವಾಗಿ ಉಪಯೋಗಿಸ್ಕೊಂಡಿದ್ದೀವಿ. ಆ ಮೈದಾನದಲ್ಲಿ ಕಾರ್ಮಿಕರಿಗೆ, ಬಡವರಿಗೆ ಫುಡ್ ಕಿಟ್ಸ್ ಅನ್ನು ಕೊಡೋದು ಮತ್ತು ಮಾಸ್ಕ್ಗಳು ಇತ್ಯಾದಿ ಜೀವರಕ್ಷಣೆ ವ್ಯವಸ್ಥೆಗಳು ಯಾವುದಿತ್ತೋ ಅದನ್ನೆಲ್ಲವನ್ನು ಮಾಡೋದಕ್ಕೆ ಈ ಮೈದಾನವನ್ನು ಅವರು ಬಿಟ್ಕೊಟ್ಟಿದ್ರು. ಹೀಗಾಗಿ ಈ ಸಾಮಾಜಿಕ ಕೆಲಸದಲ್ಲಿ ಇಡೀ ಪಟೇಲ್ ಸಂಪತ್ ಕುಮಾರ್ ಅವರ ಕುಟುಂಬ ಯಾವತ್ತೂ ಸಹಾಯಕ್ಕೆ ನಿಲ್ತಾರೆ. ಅದಕ್ಕಾಗಿ ನಾನು ಅವರಿಗೆ ಹೃತ್ಪೂರ್ವಕವಾದಂಥ ಅಭಿನಂದನೆಗಳನ್ನು ಸಲ್ಲಿಸ್ತೇನೆ. ಸ್ನೇಹಿತರೆ, ನಾನು ಬೇಸಿಕಲಿ ಐ ಆಮ್ ಸಿವಿಲ್ ಇಂಜಿನಿಯರ್, ಐ ಆಮ್ ನಾಟ್ ಎ ಲಾಯರ್. When Santosh Shetty is here, he can speak very well about the laws. He can guide you all. But one thing is there. In this vicious circle, Santosh Shetty has maintained as a model person in the law faculty. Not only that, I said in Canada, he started a movement against the corruption. Whether it may be Congress government, whether it may be politician, whether it may be bureaucrat, whether it may be BJP, he has started through his position several reforms he has made, and several punishments also he did for the concerned persons who have indulged in the corruption practices. So now I cannot say this in front of all the dignitaries. Even the courts and judges are corrupt. So you cannot, I am not saying that all are corrupt, but most of this area is got corrupted. You are all upcoming lawyers, don't know who will become a judge. You need to practice like Santosh Shetty. He never made any injustice for the judgments. Now also, after his retirement from Lokayukta, he is monitoring our 2 lakes in our constituency, which he is appointed by the NGT. One is very close by, that is Vedandur Lake. Another is Vartur Lake. NGT has appointed him to monitor PDA. Just I was telling him, sir, please look into it for Vedandur Lake. The contractor is so, I am not saying lazy, he does the correct practices. And more money has been spent for that, for rejuvenation of the lake. So he said, definitely, I have been monitoring it, definitely you will do it. Friends, you are participating in a MOOT course. Don't hesitate to argue whatever you think is right. And don't first competition I heard people from southern state also participating in this. I wish all of you, if you are winning here or not is not the issue. You should win in your life as a model lawyer, or if you are going to be a judge, model judge like Santosh Hegde. Thank you.
ಕಾರ್ಯಕ್ರಮ ಒಂದು ಅರ್ಥಪೂರ್ಣ ಕಾರ್ಯಕ್ರಮ. ಯಾಕೆಂದರೆ ಮುಂದೆ ಈ ವಿದ್ಯಾರ್ಥಿಗಳು ತಮ್ಮ ಕಾನೂನು ಪದವಿ ಪಡೆದ ನಂತರ ಕೋರ್ಟಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡಬೇಕಾಗ್ತದೆ. ಅದಕ್ಕೆ ಈವಾಗಲೇ ಅವರಿಗೆ ಒಂದು ದಾರಿ ತೋರಿಸ್ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಕೋರ್ಟಲ್ಲಿ ಯಾವ ರೀತಿ ಕೇಸ್ಗಳನ್ನು ಅಧ್ಯಯನ ಮಾಡಬೇಕು, ಯಾವ ರೀತಿ ಆರ್ಗ್ಯೂ ಮಾಡಬೇಕು, ಯಾವ ಪಾಯಿಂಟ್ ಮೊದಲು ಹೇಳಬೇಕು, ಯಾವ ಪಾಯಿಂಟ್ ಆಮೇಲೆ ಹೇಳಬೇಕು ಅನ್ನೋ ವಿಚಾರದಲ್ಲಿ. ಇದೆಲ್ಲ ನನ್ನ ಕಾಲದಲ್ಲಿ ಇರಲಿಲ್ಲ. ನನ್ನ ಕಾಲದಲ್ಲಿ ನಾವು ಲಾ ಡಿಗ್ರಿ ಪಡ್ಕೊಂಡು ಬರ್ತಾಯಿದ್ವಿ. ತದನಂತರ ಇನ್ನೊಬ್ಬರು ಸೀನಿಯರ್ ಲಾಯರ್ ಆಫೀಸಲ್ಲಿ ಕಲಿತು 4-5 ವರ್ಷ ಆದರೂ ಬೇಕಾಗಿತ್ತು. ಇವಾಗ ಈ ಶಾಲೆಯಲ್ಲಿ ಕಾಲೇಜಲ್ಲಿ ಲಾ ಕಲಿತಾ ಇರುವಾಗಲೇ ಕೋರ್ಟಲ್ಲಿ ವ್ಯಾಸಂಗ ಹೆಂಗೆ ಮಾಡುವುದು ಅನ್ನೋದನ್ನು ಕಲಿಸ್ತಾ ಇದ್ದಾರೆ. ಅದನ್ನು ಭಾಳ ಉತ್ತಮವಾದ ಇದು. ಮುಂದೆ ಇವರು ಕಾಲೇಜಿಂದ ಹೊರಗೆ ಹೋದ ತಕ್ಷಣ ಲಾಯರ್ ಆಗಿಬಿಟ್ಟು ಲಾಯರ್ ಕೆಲಸ ಮಾಡ್ಬೋದು, ಯಾವ ಆಫೀಸಲ್ಲೂ ಕೆಲಸ ಮಾಡಬೇಕಾಗಿಲ್ಲ. ಅಥವಾ ಲಾ ಫರ್ಮ್ ಅಂತ ಇವಾಗ ಇದೆ, ಅಲ್ಲಿ ಇಂಥ ವ್ಯಾಸಂಗ ಮಾಡಿದವರಿಗೆ ಮೊದಲು ಕೆಲಸ ಸಿಗ್ತದೆ. ಅದರಲ್ಲೂ ಕೂಡ ಭಾಳಷ್ಟು ಪ್ರಯೋಜನ ಇದೆ. ಈ ರೀತಿಯಲ್ಲಿ ಇವತ್ತಿನ ಕಾನೂನಿನ ವಿದ್ಯೆ ಭಾಳ ಉತ್ತಮವಾದದ್ದು. ಅದಕ್ಕೆ ನಾನು ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅವರನ್ನು ಅಭಿನಂದಿಸ್ತಾ ಇದ್ದೇನೆ.
ಈಗಿನ ಹುಡುಗರಿಗೆ ಏನು ಹೇಳಕ್ಕೆ ಬರ್ತದೆ ಸರ್, ಈಗಿನ ಜನ್ರೇಷನ್ಗೆ? ಏನು ಚೇಂಜಸ್ ಇದೆ ಸರ್ ಅವಾಗಿಂದ ನೀವು ಮಾಡೋದು?
ಕಾನೂನಲ್ಲಿ ಒಂದು ದೊಡ್ಡ ಸಮಸ್ಯೆ ಬಂದಿದೆ ಇವತ್ತು ಕಾನೂನಿನ ವೃತ್ತಿಯಲ್ಲಿ. ಬಹಳ ತಡವಾಗಿ ತೀರ್ಪು ಬರ್ತಾ ಇದೆ. ಮತ್ತು ಒಂದು ಕೋರ್ಟ್ ಆದಮೇಲೆ ಮೇಲಿನ ಕೋರ್ಟ್ ಅಂತ ಎಲ್ಲ ಕೋರ್ಟಿಗೂ ಕಕ್ಷಿಗಾರರು ಹೋಗ್ತಾ ಇರ್ತಾರೆ. ಅದರಿಂದ ಕೊನೆಯ ತೀರ್ಪು ಬರುವಾಗ ಭಾಳ ತಡ ಆಗ್ತದೆ. ಇದರಿಂದ ಭಾಳಷ್ಟು ಅನ್ಯಾಯ ಆಗ್ತಾ ಇದೆ. ಇದಕ್ಕೆ ದಾರಿ ಹುಡುಕಬೇಕು. ನನ್ನ ಅನಿಸಿಕೆಯಲ್ಲಿ ಎರಡೇ ಕೋರ್ಟ್ಗಳಿದ್ರೆ ಸಾಕು ಯಾವುದೇ ಒಂದು ವಿವಾದಕ್ಕೆ. ಮೊದಲನೇ ಕೋರ್ಟು ಅಲ್ಲಿ ಸೋತವನು ಎರಡನೇ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೋದು. ಆದರೆ ಎರಡನೇ ಕೋರ್ಟಿಗೆ ಹೋಗೋ ಮೊದಲು ಆತನಿಗೆ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕು, ನನ್ನ ಕೇಸಲ್ಲಿ ಏನಾದರೂ ಹುರುಳಿದೆಯಾ ಇಲ್ವಾ ಅಂತ. ಹುರುಳು ಇಲ್ಲದೇ ಇದ್ದರೆ ಬರೀ ಸಮಯ ತೆಗೆಯೋಕ್ಕೆ ಹೋಗಬಾರ್ದು. ಇದೆಲ್ಲ ಇವತ್ತಿನ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಗೊತ್ತಾಗ್ತದೆ. ಆ ಒಂದು ಬದಲಾವಣೆ ಭಾಳ ಅಗತ್ಯವಾಗಿದೆ. ತೀರ್ಪುಗಳು ಬೇಗನೆ ಬರಬೇಕು. ಮತ್ತು ಈ ಸ್ಪೆಕ್ಯುಲೇಟಿವ್ ಲಿಟಿಗೇಷನ್ ಅಂತೇಳಿ ಅಂಥದ್ದನ್ನು ಕೋರ್ಟ್ಗಳು ಅಡ್ಮಿಟ್ ಮಾಡಬಾರ್ದು.
ಮೊದಲು ನಾವು ಪಟೇಲ್ ಪಬ್ಲಿಕ್ ಸ್ಕೂಲ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ 2006ರಲ್ಲಿ ಮಾನ್ಯ ಶ್ರೀ ಫಾರ್ಮರ್ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ H.D. ದೇವೇಗೌಡ ಅವರು ಬಂದು ಇನಾಗ್ರೇಷನ್ ಮಾಡಿ 2006ರಲ್ಲಿ ಪಟೇಲ್ ಪಬ್ಲಿಕ್ ಸ್ಕೂಲ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ವಿ. ಆಮೇಲೆ ಒಂದು 2 ವರ್ಷಕ್ಕೆ ನರ್ಸಿಂಗ್ ಕಾಲೇಜ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ವಿ 2 ವರ್ಷಕ್ಕೆ. ಅದಾದ 2008ರಲ್ಲಿ ಡಿಗ್ರಿ ಕಾಲೇಜ್ ಪಟೇಲ್ ಗ್ರೂಪ್ ಸೈನ್ಸ್ ಆ್ಯಂಡ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಂತ ಡಿಗ್ರಿ ಕಾಲೇಜ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ವಿ. 2017ರಲ್ಲಿ ಲಾ ಕಾಲೇಜ್ ಮಾಡಿದ್ವಿ. ಹೀಗೆ ಹಂತವಾಗಿ ಮಾಡಿ ಇವಾಗ ಲಾ ಕಾಲೇಜಲ್ಲಿ ಈಗ ರೀಸೆಂಟಾಗಿ 2019ರಲ್ಲಿ 5 ಇಯರ್ಸ್ ಲಾ ಕಾಲೇಜ್ ಮಾಡಿದ್ವಿ. ಈಗೀಗ ಲಾ ಕಾಲೇಜು ಮಾಡೋದಕ್ಕೆ ನಮ್ಮ ಎಲ್ಲ ಫೆಸಿಲಿಟಿ ಮೂಟ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನ್ ಇವತ್ತು ಮೂಟ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನ್ ಆಯೋಜಿಸಿದ್ವಿ. ಈ ಮೂಟ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನ್ ಹುಡುಗರಿಗೆ ಏನೇನು ಅನುಕೂಲ ಬರುತ್ತೆ, ಯಾವ ಕೋರ್ಟಲ್ಲಿ ನಮ್ಮ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಯಾವ ಥರ ಇದೆ ಆ ಥರ ಮೂಟ್ ಕೋರ್ಟ್ ಸೆಟಪ್ ಮಾಡಿದ್ವಿ. ಎಲ್ಲ ಕ್ಲಾಸ್ ರೂಮಲ್ಲೂ ಕಾನ್ಫರೆನ್ಸ್ ಹಾಲಲ್ಲೂ ಹುಡುಗರು ಇದರಲ್ಲಿ ಭಾಗವಹಿಸಿ ಆ ಮೂಟ್ ಕೋರ್ಟಲ್ಲಿ ಅವರು ಭಾಗವಹಿಸಿ ಅವರು ಮುಂದೆ ಒಳ್ಳೆಯ ನಾಗರಿಕರ ಒಳ್ಳೆಯ ವಕೀಲರಾಗೋದಕ್ಕೆ ನಾವು ಸಹಕಾರ ಮಾಡಿದ್ವಿ. ಇದನ್ನೆಲ್ಲ ಅವರ ಸದುಪಯೋಗಿಸ್ಕೊಂಡು ಒಳ್ಳೆಯ ನ್ಯಾಯಾಧೀಶರಾಗಿ ವಕೀಲರಾಗಿ ಸಮಾಜಕ್ಕೆ ಒಳ್ಳೆಯ ಕೆಲಸ ಮಾಡಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಮನವಿ ಮಾಡ್ತೀವಿ.
ಸರ್ ಇವಾಗ ಎಷ್ಟು ಜನ ಸ್ಟೂಡೆಂಟ್ ಸರ್?
ಈಗ ಮೊದಲು ನಾವು ಲಾ ಕಾಲೇಜ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದಾಗ 120 ಇಂಟೇಕ್ ಇತ್ತು. ಆಮೇಲೆ 5 ಇಯರ್ಸ್ ಮಾಡಿದಾಗ 160 ಜನಗೆ ಒಂದು ವರ್ಷಕ್ಕೆ 180 ಜನ ನಮ್ಮ ಕಾಲೇಜಲ್ಲಿ. ಈಗ ಟೋಟಲ್ ಕಾಲೇಜಲ್ಲಿ ಲಾ ಕಾಲೇಜಲ್ಲಿ 180 ಜನ ಒಂದು ವರ್ಷಕ್ಕೆ. ಈಗ ಟೋಟಲ್ ಕಾಲೇಜು ಸ್ಕೂಲೆಲ್ಲ ಸೇರಿ 2000 ಮಕ್ಕಳು ನಮ್ಮ ಕಾಲೇಜ್ ವಿದ್ಯಾಸಂಸ್ಥೆ ವ್ಯಾಸಂಗ ಮಾಡ್ತಾಯಿದ್ದಾರೆ. ಈಗ ಇದೆ ಫಸ್ಟ್ ನಮ್ಮ ಬೆಂಗಳೂರಲ್ಲಿ ನಮ್ಮ ಇದರಲ್ಲಿ ಫಸ್ಟ್ ನ್ಯಾಷನಲ್ ಮೂಟ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನು ನಮ್ಮ ಕಾಲೇಜ್ ಆಯೋಜಿಸಿದ್ವಿ. ಇದಕ್ಕೆಲ್ಲ ನಮಗೆ ಈ ದಿನ ನಮ್ಮ ಮಾನ್ಯ ಸ್ಥಳೀಯ ಶಾಸಕರಾದ ಮಾನ್ಯ ಅರವಿಂದ್ ಲಿಂಬಾವಳಿಯವರು ಮತ್ತು ಫಾರ್ಮರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜು ಮತ್ತು ಲೋಕಾಯುಕ್ತ ಆಗಿದೆ ಎನ್ ಸಂತೋಷ್ ಹೆಗ್ಡೆಯವರು ಕೂಡ ಈ ದಿನ ಬಂದು ಇನಾಗ್ರೇಷನ್ ಮಾಡಿ ಹುಡುಗರಿಗೆ ಒಳ್ಳೆಯ ಸ್ಫೂರ್ತಿ ಮತ್ತು ಉತ್ತೇಜನ ಕೊಡೋ ಥರ ಹೇಳಿದ್ದಾರೆ. ಅವರು ಅದನ್ನೇ ಹುಡುಗರು ಆ ಸ್ಫೂರ್ತಿ ತಗೊಂಡು ಮುಂದೆ ಅವರು ಒಳ್ಳೆಯ ನ್ಯಾಯಾಧೀಶರು ಮತ್ತು ಜಡ್ಜಿಗಳಾಗಿದ್ದೆ ನಾನು ಮನವಿ ಮಾಡ್ತೇನೆ.
ಸರ್ ಲಾ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಇದು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈಗ ಮಕ್ಕಳಿಗೆ ಏನು ಹೇಳ್ಬೇಕಂತ ಭವಿಷ್ಯ ಫ್ಯೂಚರ್ ಮಕ್ಕಳು ಸ್ಟೂಡೆಂಟ್
ಅದೇ ಲಾದಲ್ಲಿ
ಅವ್ರಿಗೇನು ಹೇಳ್ತೀರಾ?
ಲಾದಲ್ಲಿ ಇರೋ ಮಕ್ಕಳು ಒಳ್ಳೆ ನಮ್ಮ ಹತ್ರ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಟೀಚರ್ಸ್ಗಳಿದ್ದಾರೆ. ಮೂಟ್ ಕೋರ್ಟ್ ಇದೆ ಮತ್ತು ಇದೊಂದೇ ಅಲ್ಲ, ಅಕಾಡೆಮಿ ಅಲ್ಲ, ಪಠ್ಯೇತರ ಚಟುವಟಿಕೆಗಳು ಅಂದರೆ ಜೈಲ್ ವಿಸಿಟ್ಗಳು, ಲೀಗಲ್ ಏಡು, ಎಲ್ಲ ಚಟುವಟಿಕೆಗಳು ಮಕ್ಕಳಿಗೆ ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ. ಅದನ್ನು ಅವಳು ತಗೊಂಡು ಮೂಟ್ ಕೋರ್ಟ್ಗಳು ಮತ್ತು ಕ್ಲಾಸಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿ ಅವರು ಒಳ್ಳೆ ನ್ಯಾಯಾಧೀಶರು ಅಥವಾ ವಕೀಲರಾಗಿ ಅವಳು ಮುಂದುವರೆದು ಒಳ್ಳೆ ಸಮಾಜಕ್ಕೆ ಜನಗಳಿಗೆ ನ್ಯಾಯ ಕೊಡಿಸಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಳ್ತೀನಿ.
I study second year LLB in Patel Law College. Today was the inaugural ceremony of Patel A. Ramaiah Memorial First National Moot Court Competition. As the chief guest, we had Shri Arvind Limbavali sir, and as our inaugurator, we had Honorable Justice Santosh N. Hegde sir grace the occasion. They shared a lot of insightful words and deep conversation with the participants and the students and with all of us. So it was a very memorable event and a very memorable inauguration ceremony. This is the first time that Patel Law College has launched a moot court competition at an international level, and the response we've received from students all across India has been commendable and a great feat for our college. Like I mentioned, I am in second year LLB in Patel Law College, and the college has been supportive from the first. The faculty has been very understanding, very friendly, and they explain and help you in every way that they can. Even the non-teaching staff and the management has been a support for all our students in every aspect of our life. Be it from a very small doubt to any big issues that we face, the management and the teachers have always been there for us, and they have always had our back. So it gives me immense pride to be a part of Patel Law College and also be a part of the inaugural ceremony of the Patel A. Ramaiah Memorial First National Moot Court Competition. I am sure that this event would be a success and would set a standard for all the events that would come in the next years. So I would like to congratulate the college for setting up this event, and the students for taking part, and the participants for coming all across India and being a part of our competition, of our event. Thank you very much.
Hello, I am Rajkumar, a student of second year LLB, Patel Law College. Today it's a privilege for us that a national level moot court competition has been organized in our college. The main essence of this particular moot court competition, the students from all over India are taking part in this particular competition, and the students of law students who are pursuing 5-year course as well as 3 years course would be taking away so many inputs from this particular competition, where a model moot court hall, like a court hall would be given, and a problem would be given to the students, and the students are going to argue with respect to the petitioners as well as respondent side as well, and what cases they're going to cite, and the students who is going to have a lot of key taking away from this particular competitions, like how the court hall would be there and how an advocate should carry on his legal etiquettes and so on. And not only this, like we have eminent personalities like advocates and good professors to judge this particular competitions. So what happens is they're going to take a good feedback from them as well, like how to improve as an advocate. And the main thing for this particular competition, Santosh Hegde sir is an inauguration for this particular moot court competition, and we are proud that he is a part of it, because to talk about Santosh Hegde sir, he was a Karnataka Lokayukta, he was a person, and former Supreme Court of India. So such big eminent personality coming to our campus and witnessing this particular event is really proud for us. And I am sure that all the students are going to have a good takeaway for this particular national level moot court competition. Thank you.